Grace and peace, everybody. We are back. You saw the thumbnail. You saw the title. You know what we're about to do. We are going to jump in and talk about this motion to dismiss the Macron versus Candace Owens lawsuit. So earlier today, I read the docket that explained how they filed. Let me pull that docket in real quick. I'm trying to be astute over here. All right, that is the motion. Sorry about that. That's not the docket. All right. So earlier today, I read the docket that explained how they were asking for the case to be dismissed. And of course, we were talking about why and such like that. And I said, as soon as I get an opportunity, as soon as I find access to it, I'm going to bring in the actual motion. Well, I got the motion. But I did want to show real quick as I'm over here fumbling around. There we go. All right. So here's the docket. And we saw that they filed it. And it's, of course, now up to the judge to decide, is he or she going to keep it? Are they going to allow it to stay? Or are they going to say, nah, you're right, we should throw this out? I'm going to have to tell you, because I read through it, kind of made some notes and stuff like that. And I'm going to go over the high points of it. They make a solid case. They make a case that we kind of all saw coming. There's a lot of things in here that we all said, oh, we know they're going to talk about this, or we know they're going to talk about that. And they didn't disappoint. But it does sound like that. I don't agree with it, but at least it's not as shoestring together, or it's not as half baked as we might have thought it would be. So it's actually pretty good. Now, let me, with all sincerity, hold on. Somebody just text me real quick. In all sincerity, let me make sure I have this one ready and queued up. So what I'm going to do is I'm just going to go over the motion to dismiss. There's 4 major points. So let me bring this in first and talk about it very quickly, which we're not going to be super long, but it is interesting. I have to admit, I kind of surprised how interesting it actually was, but where is it? There it is, right to there, Jason. All right, we got it. Let's bring it in. With no further ado, got it. All right. Whew. I don't know what's wrong with me. I'm gonna get tech support. Get him some help over at tech support. All right. I don't know how people do this with all by themselves. I mean, hats off to people that do this all by themselves all the time. Because I tell you, man, I'm making a fool of this. Okay. So, of course, this was filed on September 12th, and this is the motion to dismiss. Basically, throw the whole thing out. Just get rid of it, put it in the trash bin. All right. Defendant's opening brief support. Here's the motion to dismiss. I'm going to just scroll down to, again, the high water marks that I really think are most important. This document that I'm going over is in the description to this video, as well as the docket that I read this morning. So feel free to jump in there and follow along, all that kind of good stuff like that. Okay, table of authorities, we know that. There is the introduction, and then the statement of facts. We're going to go over those. Then there's a statement of questions involved, and then they get into the arguments. There's 4 major points, and I'll just read them to you because I do think they're kind of interesting. They're things that we thought that Candace would bring up. So let's talk about it. First one, A, is this court lacks personal jurisdiction over Ms. Owens. We talked about that because she's in Tennessee, they're in Delaware. I mean, the court is in Delaware. That's what she's arguing. This one I didn't see coming, though. The Macron's claims are time barred, and we'll read about it. This is something I didn't know about. So this new information that we're learning. C, or the third one, this court should dismiss the stay, or stay the case under the doctrine of forum non-conveniens. And we'll talk about that a little bit more. And then the very last one is D, or the fourth one, the sixth factor of all other practical problems that may, or rather that would make the trial easy expeditious or inexpensive ways in favor of dismissal. That was a very interesting take. I did not see that one coming. And then, of course, the conclusion. I won't be super long. There's going to be some that I can kind of breeze over, and we'll get started going over this. So thank y'all so much for tapping in with us. What's going on, Willis, man? They'll make an example out of Candace. I think so, but hey, let's just read it. Let's just go over it, and we'll see together. So the first part of her claim is basically on page 1 and page 2. And these are just basically all their notes. Right here, I'm kind of scrolling through in the introduction. All right. And that looks pretty good. Let's go. In contravention of a sacred precept, the U.S. constitutional law, the president and first lady of France, Emmanuel and Brigitte Macron, have filed a baseless defamation suit against an independent American journalist who broadcasts a daily news and culture show from her basement in Nashville, Tennessee. Talk about coming out swinging. The Macrons are upset that defendant Candace Owens produced an opinion-based series discussing the Macrons' relationship, their family histories, and the rise to fame, power, and influence. I don't know about that one. I don't know. I don't know if that one really flies. I don't think it was, that was not just an opinion piece. I mean, it's literally called Becoming Brigitte. I mean, it is about the man becoming a woman. Like, I don't know about that one. And I do think it's interesting. And the reason I think they're being a little bit duplicitous here is they don't say the name of it. They don't say, if they were proud of it, they would say the opinion piece, Becoming Brigitte series discussing Macron. They don't do that. The court, however, along with all other state and federal courts in the United States, including the Supreme Court, has protected journalists' First Amendment rights to produce such content since our nation's founding. When I was reading this, I just wondered, like, how do you know that? How do you get away with saying you're a journalist? Is there any kind of hoops that you have to go through in order to say that you're a journalist? Because, like, what would stop anybody from saying, "Oh, I'm a journalist. I'm doing journalism"? Like, what would stop them from being able to do this? I didn't understand, because I don't know. Does she have to go to school and be classically trained as a journalist? Does she have to work at a newspaper or a magazine as a journalist? How do you become a journalist? Because I don't think she went to school to be a journalist. I don't think she finished. So I don't know. It was already getting out kind of rocky. And I just didn't understand this. You didn't claim that your magnum opus, Becoming Brigitte, and you're claiming to be a journalist, but how do you get to do that? So let's keep going. The French president and his wife cynically avoided filing their Francocentric, I love that, Francocentric case in their home country. The reason is clear. This matter is not a legitimate legal action, but rather a transparent ruse orchestrated by plaintiff's high-profile, or rather high-priced public relations firm. For the life of me, I don't understand why she keeps saying that this is a PR stunt. What is the basis? What do they need PR for? Now, granted, France is on fire right now, but that's beside the point. Why do they need a PR move? Why does she keep saying that? And so I was a little confused. Like, why do you keep saying this is a PR stunt? Now, if he was going to run for president again, or I don't know, prime minister or grand poobah of whatever, the multiverse, maybe that would make sense. But I don't think he's trying to go back into public office again after this, my thought. So I don't understand why she keeps saying it's a PR stunt, but let's keep going. And by the way, thank y'all so much for jumping in. Everybody who's jumped in, please know that what I'm reading, this motion of Candace's to dismiss the case, is listed down in the description of this video. Had the Macrons actually suffered reputational harm from Mrs. Owens' opinion piece? They like to say it's an opinion piece. Okay. And were they serious about clearing their names or protecting their reputations, they would have filed suit in France within the acceptable, or rather applicable, limitation period. There is a time frame that they're leaning on, saying that there's a certain amount of time that the Macrons have in order to file a suit in France, and that time, that statute of limitation has expired, which is interesting, but we'll get there in a second. But legitimate vindication of their rights has never been the Macrons' intent, nor were their reputations injured. Instead, they wanted Mrs. Owens, a popular and opinionated journalist, to halt her investigative research and commentary about the French president, his wife, and those appointed by or associated with them. Again, I don't think this is being very truthful. The lion's share of what they're talking about is not who Macron hired to be chief dog walker. The big issue is the fact that she says Brigitte Macron is a man. That is the issue. And I don't know why they're not addressing that in real time. To stifle Ms. Owens' freedom of speech, the Macrons initiated a well-documented publicity campaign against Ms. Owens personally, including public threats of litigation and other retaliatory actions. Candace saying, I don't mean to keep stopping, but I'm like, wait, hold on. Candace is the one that says, come on and sue me. She literally said that. She said, come on and sue me. I dare you. The intro, in my opinion, is not the strongest point. Some of the arguments, the A, B, C, and D, to me, they seem strong. This one just doesn't seem like the best, because it just seems like you're not being honest. You're not holding. This is not the truth, the whole truth, and nothing but the truth type of scenario. Therefore, because Ms. Owens refused to be intimidated, the Macrons filed a suit in Delaware in an attempt to bypass France's 3-month statute of limitation for defamation, which bars the Macrons' claims. I didn't fully understand how the Macrons had a 3-month statute of limitation when she literally was saying it in real time. Like, well, how do you determine the statute of limitation when she just said it today? She said it yesterday or whenever. So we'll see in a second. Although the Macrons' lawsuit violates fundamental First Amendment guarantees, the court need not reach those issues here. The Macrons' complaint and each claim within fails as a matter of law on 3 dispositive threshold grounds. First, the Macrons do not and cannot establish this court's jurisdiction over Ms. Owens, which is weird. Oh, that's strange. That's where your business is. I do think it's interesting they keep saying Ms. Owens and not her LLC, and not Tom George or whatever her husband's LLC is. It seems like they're just kind of ignoring that little factoid. As set forth below, Ms. Owens has no material contracts with the state of Delaware, and she certainly is not at home in the state. That's where your business is, though. They're suing your business. Thus, the court has no basis for exercising general jurisdiction over her. The Macrons attempt to establish personal jurisdiction over Ms. Owens under all this good stuff right there as a threshold matter. The Macrons failed to serve her under Statute 109 and Section 18109 permits implied consent jurisdiction for managers of Delaware limited liability companies only in action involving or related to the business of the limited liability company. But isn't that what they're in business for? Isn't that why you have a limited liability company? In order that you have limited liability if you are sued. Like, involving or relating to the business of the limited liability company, which the Macrons' suit is not. Moreover, exercising jurisdiction over Ms. Owens would contravene the due process clause of the 14th Amendment. I personally think this is a very weak argument, but I'm looking forward to seeing how a judge responds, because her company is housed, is structured, was formed in Delaware. That's where you sue her. in Delaware. I don't understand that. But let's continue. Second, in Macron's lawsuit is quintessential libel tourism, which is crazy. Libel tourism, motivated solely by the Macron's attempt to evade France's 3-month statute of limitations for defamation, which is disputative. I don't understand this. This is a very confusing one. Instead of suing in her home country, in their home country, where their alleged harm was incurred, or the Tennessee, where the alleged defamatory statements were published, the Macron sued in Delaware, which it has no connection with the Macrons and no connection with Ms. Owens, which is not true, and no connection with the claims alleged. That's not true. That's where your business, that's where your company is. To me, I'm like, if you're going to sue Mercedes-Benz, you would probably sue them wherever the company is headquartered, and you're headquartered in your limited liability is in Delaware. Candace, I don't know about Mercedes-Benz, probably wasn't a good example, but you get my point. The Macron's ill-conceived gambit, however, falls short. Delaware's borrowing statute explicitly prohibits the sort of forum shopping. This is hilarious how they keep impugning what they're doing. And because it requires that the court to apply France's 3-month statute of limitation, the complaint must be dismissed in its entirety. It seems like they're mixing and mingling. They want some of France's laws brought to the United States, but they don't want France to violate the First Amendment here. And it just seems like they're just kind of, I think the tourism claim is kind of, I think they fall under the tourism claim, if you ask me, but I continue. And third, the Macron's claim should be dismissed under this doctrine of form, not convenience. Ms. Owens will suffer overwhelming hardship if she is forced to expend significant unnecessary resources in a battle with a major international head of a state in a jurisdiction that has no connection to the claims, parties, or operative facts in issue in the litigation. I kind of think this one's, again, though I disagree, this one sounds right. Like, look, she got to travel to Tennessee to deal with this. I'm a little bit surprised they didn't throw in kids in there just to, make sure that they add a little extra pulling on the heartstrings. But let's continue. There also are no relevant witness or evidence located in Delaware, nor would any substantive Delaware law apply to the defamation suit brought by the French president and the first lady against the independent Tennessee journalist. Thus, the court should dismiss the Macron's complaint in its entirety. That's probably the only one I like, and it seemed like it makes sense. Like, you're putting a hardship and a burden on her to have to go to Tennessee, come from Tennessee to Delaware. But ma'am, remember, if I were Candace's attorneys, I would just play Candace goading them and mocking them and saying, come on, sue me. I'll pay your legal fees, all that kind of stuff like that. Let the judge see that. And to me, I think it's a wrap. Statement of facts. Emmanuel Macron is the current president of France. Okay, we already know that. Brigitte Macron is the first lady. Mrs. Owens is an independent investigative journalist who has, at all relevant time, has been a resident and documenter of the state of domiciliary of the state of Tennessee. Yeah, I guess they're saying she lives in Tennessee. But has she always lived in Tennessee? I thought she lived somewhere else at one point. Okay, anyway. Ms. Owens is not and never has been a Delaware resident. Okay, maybe not. Okay. Ms. Owens does not and never has owned real estate in Delaware, just as she does not conduct or has not conducted business in Delaware. See, that's that part right there. I don't think that's true. Because they mention that, she has an actual LLC that's formulated in Delaware. Why is it there? Let's see what they got going. Candace Owens LLC is a limited liability company in Georgetown, Inc., a corporation both formed in the state of Delaware and headquartered in Nashville, Tennessee. That's the only thing that to me seems like it could be uh, a slam dunk to get it out of Delaware and get it to Tennessee. It's just that it's headquartered in Nashville. But that's the only thing. The rest of it, I know. I can see why they did it. So I want to see how the judge decides. Neither maintains a physical presence in Delaware, nor has either taken any action to target or serve the Delaware market. Ms. Owens runs her journalistic operation with the help of 3 employees from the basement of her home in Nashville, Tennessee. All of Ms. Owens' employees, producers, editors, and contributors live and work in Nashville, Tennessee, and in the surrounding areas. Owens, all documents related to her work, as well as the relevant books and records of Candace Owens, LLC, and Georgetown LLC, are in Nashville, Tennessee. Ms. Owens operates her main journalistic endeavor, her podcast, Candace, from the Nashville basement. They like saying that she's coming out of the basement. I don't know, because Rush Limbaugh used to say that too. Or it was a bunker. Rush Limbaugh used to say a bunker. To me, that's the only thing that makes sense. If the judge accepts anything, I could see him saying that it might need to go to Tennessee for this reason. That's the only thing. The rest of it, yeah, I don't know. I don't think that the rest of it is a good argument, in my opinion. Between January 3rd, or 31st, 2025, and February 20th, 2025, Ms. Owens broadcast an 8-part series entitled Becoming Brigitte, in which Ms. Owens discussed Emmanuel Macron, Brigitte Macron, and the relationship of their rise in prominence through the ranks of the French politics. Okay, and let me know, because to me, this seems like an ongoing offense. Because this is what they're trying to use. They're going to try to use this as the 3-month marker. So if it ended in February, there would be March, April, May. They should have sued them in May is basically what they're insinuating. I don't know why that. And here it comes. You'll see right here. On January 23rd, 2025, the Macrons filed their complaint here. The Macrons alleged a defamation against the Tennessee journalist for statements made in a Nashville basement. Y'all stop with the Nashville basement. They need to quit. In a Nashville basement, which the Macrons allege have caused harm in France. Yet the Macrons filed an action in Delaware state court, notwithstanding that Delaware has no connection to the subject matter or operative facts of this dispute. That's the only thing. I can see if a judge said, man, I don't want anything to do with this, and just punts it over to Tennessee. That's the only thing I can think of. I don't agree with it, but that's probably the best argument I've heard so far. Statement and questions involved. Whether Candace Owens should be dismissed from this action because this court lacks personal jurisdiction over her. I think they do, because that's where her business is. That's where her business LLC was formulated. It can't just be a boneheaded decision that, we should have filed it where it was headquartered. It had to be a good reason why they did that. Whether France's 3-month statute of limitation bars the Macron's claim. I don't think they made a good case for this. I don't think they're making a good claim at all. And we'll see in a second, because it's been ongoing. Matter of fact, as recently as just a couple of weeks ago, she was talking about she's going to do another series on it, start again. Was it season 2? There's been a lot about this, and it just seems adorable. She doesn't mention that whole thing about the Macron, Brigitte Macron being a man. They mention, their relationship, the rise to power, people in their cabinet. No, man, it was dude looks like a lady. That's what they're suing you about. Whether this action should be dismissed because it would cause defendants overwhelming hardship to proceed in Delaware. That's the only thing I think that they can get away with. The other two, I don't think are solid. I'm kind of surprised they didn't bring in kids. At this point in the game, I'm kind of surprised they didn't bring in, like, she has young kids and she's gonna have to, find a babysitter, or she, something like that. I'm really surprised they didn't bring that in. But that's probably, in my opinion, based upon information belief, that's probably the best argument right there. It's just a hassle to go all the way from Tennessee to Delaware. Well, I mean, you dared them to sue you. That's my only thing. Even as I argue with myself here, you dared them to sue you, Candace, and they took you up on it. They said, hold my croissant and my triple soy latte, and they did exactly what you asked them to do, sue you. Argument. Under Superior Court Civil Rule 12b-6, dismissal is appropriate when it appears with reasonable certainty that under any set of facts that could be proven to support the claims asserted, the plaintiff would not be entitled to relief. So basically, y'all ain't gonna get nothing from me, so y'all might as well just go ahead and throw it out. Or like, just go and throw it out. And as I think about this, wouldn't the Macrons have to come to court too? They're not gonna be doing this by proxy. So who's gonna have more of a headache and a burden? Candace coming from Tennessee to Delaware, or these rascals going from France to Delaware? I still think it's a bad look either way, but I think the Macrons would probably have more of a hassle. Interesting. Yeah, that's what I'm thinking, but we'll see. Although the court must draw all reasonable inferences in favor of the non-moving party, it is not required to accept every strained interpretation of the allegation proposed by the plaintiff, nor should the court draw unreasonable inferences in favor of the non-moving party. Who is the non-moving party? I feel like my legal background is running amok. All right, let's go. I have no legal background, Jason. Moreover, a plaintiff must plead all elements of its claim without the court having to consider conclusionary allegations that lack the specific supporting factual allegations. Okay. As set forth below, the complaint must be dismissed for several reasons. First, the court cannot exercise jurisdiction over Ms. Owens, either generally or specifically under 6 Delaware Charlie squiggly line 18109. Second, under Delaware's borrowing statute, which mandates application of French procedural law, and specifically France's statute of limitation of defamation, the Macron's lawsuit is time barred. Lastly, the doctrine of form non-conveniencies militates in favor of dismissal here. Each of these grounds of dismissal, or rather for dismissal, is independently dispositive. All right. If I had to put these in order, I think the court does have jurisdiction because that's where her LLC is. I also think that the statute of limitation claim falls short because it was ongoing. They're kind of trying to make this claim that when the video series ended, that's when the offense clock started, the 3-month timer started. And I don't think that works. But also, that's how they do it in France. It has nothing to do here in the United States. So we don't have a statute of limitations like that. So for them to bring in here, French procedural law, well, France, they do a whole bunch of stuff that we don't do. So I'm not 100% certain that's the best argument. I think probably the best argument they can make, really in all seriousness, is the situation where it's going to be a hardship to move from Tennessee to Delaware. You don't have a home. You don't have property there. It's going to be a hardship to do that because you live in Tennessee. That's probably the best argument I think she has. But let's keep going. The court lacks personal jurisdiction over Ms. Owens. I don't think this is true. I truly don't think this is true. But let's keep going. Delaware courts may exercise jurisdiction over a non-residential defendant as a function of other specific general jurisdiction. But if you live in Omaha and you go to Missouri and you commit a crime in Missouri, they're not going to sue you and go to trial and all that kind of good jazz in Omaha. You're going to do all that stuff in Missouri. And if it's federal, you're going to go to federal jail. I mean, to me, I don't think that that's a good, I definitely want to hear how the judge moves with this one, though. When a defendant moves to dismiss the complaint under Rule 12b2 for lack of personal jurisdiction, the plaintiff bears the burden of showing a basis for the court's exercise of jurisdiction over the defendant. I thought they made a pretty good claim that this is where your business was started, where your LLC is housed, not where you actually do business at. I don't think, we'll see. We will see. I'm looking forward to seeing how the judge moves. Delaware courts should exercise caution in extending jurisdiction over non-resident defendants with tenuous ties to Delaware. General jurisdiction allows courts to exercise jurisdiction over non-resident defendants for actions entirely unrelated to Delaware, while specific jurisdiction allows courts to exercise jurisdiction over non-resident defendants only where the action arises out of or relates to the defendant's contact with Delaware. But isn't that where your business is? To me, I feel like you're just kind of overlooking, like, yeah, I don't live in Delaware, but that's where your business is situated. And I'm sure there's been other cases as well where people had to go somewhere because this is where they were being sued. I don't think that this is the first time ever that somebody has argued that I'm suing you in Washington State and you might live in Miami. Oh, that would be miserable. That would be super miserable. To determine whether a plaintiff has adequately alleged either general or specific jurisdiction under Delaware law on a motion to dismiss, the court engages in a two-step analysis. First, the court must determine whether Delaware statutory law offers a means for exercising personal jurisdiction over the non-resident defendant. Okay. Do you have reason to rule over me? Got it. Second, the court considers whether subjecting a non-resident defendant to jurisdiction in Delaware violates the due process clause of the 14th Amendment. I thought that was kind of interesting that they brought that in there, but okay. The court moves to the second step only after the first step has been satisfied. Both must be met before the court will exercise personal jurisdiction over a defendant. My only thought process here is they're kind of setting up for, in my opinion, for an appeal. So if they say, hey, if they lose, they'll go to appeals and say, well, it should never have been in Delaware in the first place. And here's the reason why. Candace lives in Tennessee and the case was in Delaware. To me, I think they're kind of set up for an appeal if they lose. And who knows, maybe it'll happen, but we'll see what happens with the judge for sure. The court moves in the second step. I only just read that. The Macrons cannot meet their burdens as either step. All right, so now they slam dunked them. Now we're going to talk about what are the general jurisdictions. Let's go. The Macrons allege the court general jurisdiction over Ms. Owens pursuant to Delaware, 10 Delaware, Charlie, squiggly line, 3104, Charlie 4. I'm not going to read all those. The law is clear, however, that section this and that, a general jurisdiction provision requiring that the defendant have greater contacts with the forum state. Okay. Then kick your LLC out of, can they kick your LLC out of Delaware and say you got to reform it in Tennessee? Like, what was the reason why she started her LLC in Delaware in the first place? To me, that kind of solidifies it. You do have roots, even though you don't have a physical address or property or whatnot. You really did. Why did you start your LLC in Delaware? Is my question. Accordingly, the Macrons have the burden to produce evidence that Mrs. Owens regularly does or solicits business in this state, engages in any other pursuant course of conduct here, or derives substantive revenue from the services or things used or consumed in Delaware. It doesn't all of your business come from there? To me, because, and I do know it's tax purposes why people start the LLC in Delaware. But isn't that kind of the benefit? Aren't you deriving services and benefits because it's tax advantageous to start your business in Delaware and pay taxes that way versus the other way? I'm just wondering. It just seems like, I don't know, man. I think they're trying to have their cake and eat it too. Further, for the exercise of general jurisdiction, to comport with the due process, a defendant must be essentially at home in that state. That one could be a little bit rough. For the individual, the paradigm form for the exercise of general jurisdiction is individuals' domicile. Thus, only a limited set of affirmations, or rather, affiliations with the form will render a defendant amenable to all-purpose jurisdiction there. That's the only thing. Like, she doesn't live there, and I can see that one coming back to bite them because she doesn't live there, never has, never will be living there, unless they say you better bring your happy self on over here to Delaware. I guess they're gonna be staying in an Airbnb or something, but I'm wondering if they're going to say that because you're doing business there. And this is not the first person that's been sued in Delaware who maybe lived in another state. So I'm pretty sure there's some case law. I'm pretty sure there are examples that they could point to and say, well, this person was living in, Massachusetts and had to come down here. This person was living in Texas and had to come up here. Whatever like that. So I'm pretty sure this is not the first time. Under the U.S. Supreme Court's decision of Daimler, a defendant is not subject to general jurisdiction wherever it is engaging in a substantive, continuous, and systematic course of business, unless it is essentially at home in the form state. I mean, I got you. I understand that. Doing business in Delaware is insufficient to confer general jurisdiction in Delaware over a dispute that is otherwise unknown to the state. I get it. The Macrons do not and cannot show that Ms. Owens is essentially at home in Delaware. I guess you got it. I understand it. Their paradigmatic place where Ms. Owens would be subject to general jurisdiction is Tennessee, where she is domiciled, not Delaware, where she is not and has never been a resident. Ms. Owens does not own or does not own real estate in Delaware. Affidavit, sorry. She does not conduct business in Delaware. Owens, moreover, of the Macron's complaint alleges occurred in Delaware. Rather, the Macron's allegations are based entirely on statements allegedly made by Ms. Owens. Wait. Rather, the Macron's allegations are based entirely on statements allegedly made in Ms. Owens' 8-part podcast series, which she broadcasts from Tennessee. Okay. Why do you say allegedly? She did say that stuff, man. Come on now, my guy. Y'all did say that. Accordingly, this court lacks general jurisdiction over Ms. Owens. I mean, I hear them. Y'all in the chat real quick. Do you think, just comment, type DE if you think she is going to stay in Delaware. Type TN if you think it belongs in Tennessee. Just real quick. There's 108 people in the chat real quick. I just want to see what y'all think. Okay, I see some Delaware popping up. All right, so Shabui. Oh, neither. Oh, neither. Okay, that was an option, I guess, too. All right. Looks like another Delaware person, another Delaware. Okay. Interesting. Okay. Yeah. To me, I understand why they did it in Delaware. It makes sense. They're suing the LLC. I got you. I don't think I agree with how they're. The only thing is the fact that she didn't live in Delaware. If she had ever lived there, I think it would have been like a slam dunk. But let's keep going. Shout out to she was saying. She was trying to get Candace Owens, the person dismissed from the suit based on. I understand it, but it seems like in comment was that they're trying to get Candace released from the suit, but they mentioned the LLC, and to me, I think I don't know if they can divide it like that. And hey, we're gonna all find out together. Shout out for sure. All right, the Macrons also attempt to establish personal jurisdiction over Miss Owens, pursuant to Delaware Charlie squiggly line 18109 complaint. This attempt fails for 3 reasons. The Macrons did not properly serve her under Section 18109. The terms of the statute do not confer jurisdiction over Miss Owens, and exercising specific personal jurisdiction over Miss Owens would contravene due process. Okay, we kind of talked about that. That one is definitely a sticky wicket. Let's see what they say. I don't think that the Macrons. I don't think Of course, this is a lawyer back and forth, but I don't think the Macrons hired just anybody. They didn't hire me, because Lord knows they'd be in trouble if they hired me. So I'm trusting that the lawyers that they selected for the right reason, and they got the right people for this case. They didn't just pick anybody, go through the yellow pages or whatever. Do people still use yellow pages? So I think they got the right ones. But let's keep going. Superior Court civil rule requires dismissal of a claim if that claim's service of process is insufficient as to the rules of civil procedure in the state of Delaware. Okay. Proper service of process is jurisdictional requirement. So a failure to properly serve a defendant requires dismissal without prejudice. How did they file? I don't remember how they served them. I thought they served her attorneys, which I thought was the right thing to do. Yeah, this is going to be very interesting. Okay. Somebody said right here, returns of her merch is sent to the Delaware office, which is where the Delaware Sheriff's Department tried to serve the lawsuit originally, thus per the last court filing. Interesting. Yeah. And I'm sorry, I shouldn't have said the Macrons. I should have said the court. Okay, where are we at? It is indisputed, one, that the Macrons did not serve Miss Owens through the registered agent of Candace Owens LLC, which again, like it seemed like she's trying to get both, and like you're using Candace Owens LLC here, but then you're trying to get Candace separated from it. Okay. The proprietary did not mail the service to Miss Owens, and 3, the Macrons did not obtain summons under Section 18109 D1I. Accordingly, the Macrons cannot obtain jurisdiction over Miss Owens through Section 18. I'm not going to read all these. Even if the LLC constant statute could be applied to the instance plaintiff has not availed itself of the LLC consent statute by following its statutory requirements because defendant was served under the statutory procedures of the long arm statute, not the LLC consent statute. Okay, that means basically they served them a different way than what they could serve or should serve in Delaware. I don't know. Man, I really can't wait to see what the judge says. Alternatively, dismissal would be appropriate under Rule 12b-5, given the Macron's failure to comply with Section 18109C. I don't know how they're going to get away with that. Okay, and then let's finish this part up. The second reason, B, Section 18109 does not apply here, even ignoring the Macron's fail to effect adequate service. Managers of the Delaware limited liability companies impendingly consent to personal jurisdiction only for actions involving and related to 1, the business of the limited liability company, 2, violation by the manager or liquidating trustee of the duty to the limited liability company or any member of the limited liability company. Okay. But wouldn't being served or being sued be part of the reason why you have a limited liability company? The Macrons claim that the court has jurisdiction because their claims relate to the business of the limited liability company. That's what I'm thinking. They are wrong. I don't understand how you came to that. Delaware courts construe that statute to narrowly referring to corporate governance and internal affairs of the LLC. Delaware courts construe this statute to narrowly refer to the corporate governance and internal affairs of the LLC. So I guess being sued doesn't fall under that. Okay. To determine whether an action involves or relates to the business of the LLC, the Court of Chancery has employed 3-part test to consider whether the allegations against the manager focus centrally on his rights and duties and obligations as a manager of the Delaware LLC. Okay. The resolution of this matter is inextricably bound to the Delaware law, and the Delaware has a strong interest in providing a forum for disputes relating to the ability of the managers of the LLC formed under the law to properly discharge their respective managerial functions. Okay. I mean, they're making a case. I just don't know if I agree with it, but most importantly, does the judge agree with them is what really matters. None of these elements are satisfied here. I guess I would wonder, and hence, sadly, I was not able to get a legal expert to come on, but I kind of wonder, what would it look like? What would the proper, assuming that Delaware has jurisdiction, what would it look like? Would they had to, what would be the proper way to go about serving this lawsuit? How would it gone about in order to hit all of these markers? Because otherwise it's like, well, why do you allow them to be in Delaware if you can't use that as a means to sue them? And then also, why is it that, because Candace has been in communication, her attorneys have been in communication with the Macron's attorneys before all of this, per her testimony. Why did they have a means of communicating and being able to, like, okay, we're going to file this lawsuit and we actually have a means of communicating with you, whether it be the lawyer's office or however you're going to go about it? Why did they not have that? Even if this court does not apply the 3-part test, the Macron's claim do not relate to the business of Candace Owens LLC under Section 18109, Next Level Ventures. LLC holds the claims that they relate to running an LLC day-to-day business can fall within the scope of Section 18109. I'm not going to read all that. Skip that. This states that Corollary states a corollary. Claims fall outside of the scope in Section 18109 where they do not relate to the rights, duties, and responsibilities of the defendant owes to the LLC or in any other way the internal business affairs of the LLC or to the running of the LLC's day-to-day operations. But so where would fielding lawsuits come from? Where would that fall in the day-to-day operation? Of course, hopefully not getting sued every day, but I think that just seems like how would you go about that? Okay, just recently, the Court of Chancery refused to apply Section 18109, where none of the plaintiff's allegations concern the LLC's business or governance. But being sued is a part of the governance, isn't it? And definitely part of your business. All right, let's keep going. And by the way, thank you so much for jumping in. If you want to follow along, this document is actually attached to the description of this video. And I'm just going over Candace Owens' motion to dismiss the Macron lawsuit. It's interesting. I don't think it's going to pass the muster, but who knows? Who knows? Crazier things have happened. Where, as here, the claims of the issue challenge a manager's tortious conduct, independent of the LLC Section 18109, does not apply. Rejecting application of Section 18109 to claims involving Lynch's personal stake in HFS, where defendants have failed to demonstrate that it is in any way related to the Belleville managerial duties. Okay. To me, I still don't get why that matters. Like, where would you actually process a lawsuit, or where would you serve a lawsuit in this case? The allegations of the complaint are entirely unrelated to Ms. Owens' rights, duties, and obligations as a manager of Candace Owens LLC. The claims here are for defamation involving statements that Ms. Owens herself made on her Imponiousness podcast. Nowhere in their lengthy complaint they brought up the fact that it was 200-something pages. Nowhere in their lengthy complaint do the Macrons allege that Ms. Owens was acting on behalf of Candace Owens LLC. Ooh, that's interesting. Nowhere do the Macrons allege that Ms. Owens' defamatory statements involve Candace Owens LLC internal business affairs or the running of his day-to-day operations. Section 18109 simply does not apply here. And keep it moving. The court moves to the second prong only after the first prong has been satisfied. Even if the Macrons had demonstrated a statutory basis upon which they exercised personal jurisdiction over Ms. Owens under Section 18109, exercising personal jurisdiction over Ms. Owens would violate due process guarantees. This was really odd to me, how they went about this, and you'll see in a second. Compliance with the due process requires minimum context analysis, which seeks to determine the fairness of subjecting a non-resident defendant to a suit in a distant forum by considering all of the connections among the defendant, the forum, and its litigation. I think it's interesting because earlier they were bringing up the fact that they're from France and, French law here, French law that. What if they had sued her in France? What would Candace have done then? If they had stayed in home, and that's where they were affiliated with, of course, in France, and they said, hey, we're about to sue you in France. To me, I don't think that's a good argument, but I would love to hear, as I keep saying, what the judge decides. This inquiry is particularly important for the claims that do not relate to the LLC's internal affairs, which more readily support the due process analysis, whether the court applies a three-part section of 18109 test or uses a traditional minimum contacts analysis, exercising personal jurisdiction over Ms. Owens would be improper. I just don't see how they're doing that. I think they make a good point, but I still believe that Delaware has jurisdiction over this. And I think that the judge is going to probably say, no, I appreciate you writing that, but we're good, my guy. The three-part test is not satisfied. The claims here do not focus on Ms. Owens' rights, duties, and obligations as a manager of Candace Owens LLC. Okay. Referring to the three-part test, considering whether the allegations are consistent with the statutory waiver and constructed significantly narrow to comply with the process. None of Macron's claims relates to the corporate governance, Mrs. Owens' conduct, or rather duties as a manager or internal affairs of Candace Owens LLC. When the claims at issue bear no relationship to the duties of the manager and do not involve internal affairs of the Delaware LLC, Section 18109 does not confer personal jurisdiction over the non-resident manager. Okay, I think that. I find that plaintiff's claims do not involve or relate to the LLC's business in the sense of the internal business as required by the statute and the due process clause. To determine whether due process is satisfied under the minimum context analysis, courts seek to determine the fairness of subjecting non-residents, and this is where they're going to get to dragging her to Delaware every day, subjecting non-resident defendants to suit in a distant form by considering all of the connections among the defendant and the formal litigation. To exercise jurisdiction, there must be enough contact between the defendant and the Delaware, which such that requiring Ms. Owens to defend herself in the courts of Delaware would not offend the traditional notions of fair play and justice, because Ms. Owens should reasonably anticipate being required to defend herself in Delaware courts. That's probably the best argument that I've heard. And that's just the dragging her all the way to Delaware. She doesn't have a home there and such like that. That's the only thing I can think of. I mean, it makes sense. The other ones, I feel like, nah, just because, like, how else are you supposed to sue somebody? How else are you supposed to do that? Such potential contexts include, but are not limited to, performing services in the form state, soliciting business either through salespersons or a form state, or advertising reasonably calculated to reach a form state, making regular sales to residents in the form state, and seeking to serve the form state market. I was conflicted here. I'm like, to me, a lot of this does happen. Like you're doing business in the state. So it's not like you're just making this up. It's kind of, you're doing business in the state, and you're experiencing tax benefits because you're in this state. That's why you're not in Tennessee. That's why you're not in Georgia. That's why you're not in Montana. You're in Delaware because it's tax advantageous to do so. So to me, I feel like that one is almost, some of these other ones kind of fall by the wayside. Sure, you're not doing sales and marketing. Okay, got you. But you are benefiting from being in the state. Here, no such contacts are present. Contacts are present. Moreover, the Supreme Court has held that when there's no affiliation between the form and the underlying controversies, specific jurisdiction is lacking, regardless of the extent of the defendant's unconnected activities in the state. We're going to see. We are going to see. Ms. Owens' contacts with Delaware are simply too thin to meet the minimum context requirements. She does not reside, conduct business, or own real estate. Owens, and we already talked about that. She gave the affidavit, finding the defendants did not have sufficient contact with Delaware to subject them to this jurisdiction. The complaints 22 claims of either defamation or false light are focused exclusively on statements Ms. Owens is alleged to have made in Tennessee, in which are alleged to have been produced in entirety, or rather by entities headquartered in Tennessee. I think that's probably the best case they can make. Look, we weren't even in Delaware when we said that. But I think it's funny they keep saying allegedly. You didn't say those things. Stop it. Moreover, the Macrons do not allege that Mrs. Owens performed any services in Delaware, solicited business in Delaware through advertising, reasonably calculated to reach Delaware, made regular sales to residents of Delaware, or was specifically seeking to serve the Delaware market. Okay. I don't know. I don't think the Macrons have to reply back to this. It's the judge determining if they're making a good case. Because I can see, I'm really excited to see what the judge says here. Because again, like, you're benefiting from it because you're there. Here, let's just jump down here. And let me look at my notes real quick, because I kind of went off the reservation here. Sorry about that, y'all. Okay, this is page 18. Wait, what page are we on? Oh yeah, cool. We're on page 18. We're not that far off the mark. Okay. Here's the time barred. And this was very interesting. And I just thought this was super weird, because Candace has been saying this for a while. So I don't know how she can say that it's time barred, because there's time barred because it's been ongoing. So let's keep going. Every claim that the Macron's complaint is time barred, it should be dismissed under Delaware's borrow statute, which is designed to prevent forum shopping by non-residents. The court will apply the shorter of the limitations period of Delaware or of the state or country where the non-resident plaintiff's claim arose. In defamation cases, that typically is the place of the plaintiff's domicile. So that's the Macrons in France. As shown below, because the Macrons are French residents, and because the French statute of limitation for defamation is 3 months, as opposed to 2 years in Delaware, the 3-month limitation period applies. Thus, the Macrons' claim, all of which concern statements made more than 3 months ago, must be dismissed. I don't think that was very interesting, because Candace she just keeps saying it. But let's see, whereas here, a plaintiff who is not Delaware resident asserts the claim that arises outside of Delaware, in an action cannot be brought in Delaware to enforce such cause of action after the expiration of whichever is short of the time limited by the law and the state, or time limited by the law of the state or country where the case action arose. Okay, I'll stop right there. I think the fact that they're using when the last episode of Becoming Brigitte was released, she's not talking about shirts, she's not talking about mugs and merch, and her speaking on this topic after that fact. That's the part I don't think that's being forthright, in my opinion. The borrowing statute exists to preclude litigants like the Macrons from implementing the specific kind of forum shopping scenario present here, in which a non-resident plaintiff files in Delaware a claim that arises under the law of another jurisdiction to evade that jurisdiction's shorter statute of limitations. I wonder, but they've been saying it though, and they said it in their initial complaint. Courts applying and borrowing statute employs a two-part analysis. First, determine the jurisdiction in which the cause of action arose, and second, examining whether the claim would be time barred by the applicant limitations period in that jurisdiction. Here, the analysis confirms that France's shorter statute of limitations bars the Macron's claims. I never see them actually explain how they came up with that, how they came up with the 90-day shot clock. Like, how did y'all get that? First, where a purported defamatory statement is disseminated via the internet and thus the globally accessible, Delaware courts presume that the plaintiff suffered injury in his domicile. This is where the claim rises. Okay, there we go. Accordingly, when applying the borrowing statute to defamation claims brought by non-resident plaintiffs, Delaware courts constantly look for a statute of limitation of the plaintiff's home jurisdiction, where the Macrons are citizens of the domicile in France. But see, if they applied for this on July 23rd, that means I'm sure that they could say that she said something about them in April, May, June, July, May. I'm sure they could say that and say that's why they started the 90-day clock. But let's keep going. The presumption that the injury is suffered by the plaintiff's in the plaintiff's domicile, and that the jurisdiction where the plaintiff is domiciled is also where the plaintiff's claim arises, holds particularly true here. Plaintiffs are the president and first lady of France. Make this a little bit bigger for y'all. Of France. And their claims allege reputational harm. Thus, the Macrons' alleged reputational injury necessary would be felt primarily, if not exclusively, in France. Okay? Discussing this presumption, then Nunes suffered the greatest harm in his home state of California, among other constituents who were reasonable, or rather responsible, for sending him to Washington, D.C. in the first place. And this is just a case that they're referring to. Moreover, the Macrons' complaint alleges at length that the Macrons were born, educated, and work in France. The Macrons also allege that the President Macron founded a political movement in France, and that Mrs. Macron joined her husband on the campaign trail, acting as a central figure and key advisor to his campaign. They're like, look, man, you was born in France, you're going to die in France. All right. You've been in France, stay there. I can kind of see that. And they allege President Macron formally established an official unpaid role for the First Lady. In this capacity, Ms. Macron represents France in diplomatic settings, supports charitable causes, and engages in initiatives related to education, health, and disability, and child protection. Okay. So because you do work in France, all of this needs to be done in France. And that's all I can get from it. But we're going to see. The Macrons allege that the injuries they suffered were global and worldwide. I mean, they did say that. They cite the article claiming damages to the election hopes. The French President Macron, they vaguely claim loss of future business opportunities, presumably in France. And they allege that President Macron addressed the statements at issue to an audience of journalists in Paris. Thus, the complaint both implicitly and explicitly alleges claims of injury that are focused in France. I can kind of dig that. I can see what they're doing. Yeah. So I wonder if he said anything like at the UN, if he had gone to UN and spoke about it in New York, or went to another big whoop-to-do, some G20, and mentioned it there. I mean, he did mention it to Trump in Washington, D.C. So I'm wondering, like, what do they need to see in order to say that this could happen? But I mean, it is French, but they're alleging, I see they're doing a great job of establishing that we're talking about French people who were born and raised in France, who did business in France. So you need to stick with the French shot clock. The only thing is I couldn't get an understanding of how they determine what the shot clock, when the shot clock starts. I understand it's a 90-day shot clock, 3-month shot clock. I got you. But how do you, I wasn't clear when I read back through it, maybe I'll run across it again, but I didn't understand why they determined that the last part of the Becoming Brigitte series was when the shot clock started. That didn't make any sense to me. I hope that makes sense. Applying the French statute of limitations here is not only consistent with the borrowing statute, it also comports with the French law and policies, as Mr. Emmanuel Dreyer, an expert in French defamation law, explains that the statute that sets out a cause of action for defamation in France. The law of freedom of the press also establishes a 3-month limitation period as a matter of French public policy. Dreyer explains here, France's public policy in favor of shortened limitation period to protect freedom of expression is so strong that the limitation period cannot be waived and will apply even where any foreign law normally is applicable, provides for a longer limitation period. Certainly, there are no grounds to assert that the Macrons' cause of action rose in Delaware. Neither the Macrons nor Ms. Owens conduct business here. Owens, she's already said that. None of these parties reside here. We already know that. And the statements that the Macrons have asserted were torturous were not made here. Okay, got you. Thus, the only connection this case has with Delaware is that the two entity defendants were formed under Delaware law, but that does not provide Delaware with any interest in this case, which has nothing to do with corporate governance. All right. Like I said, I really think that's going to be, it can't be the first time somebody's sued like this in Delaware. So I'm really thinking there's going to be a lot of case law that pops up. Delaware's public interest in such cases is strong where the substantive issue is corporate governance are implied or implicated. Please forgive me. That is not the case here. This is a conduct of tort dispute. Putting the defendant's place of incorporation aside, Delaware has virtually no connection to this dispute. For these reasons, the Macrons' alleged injuries necessarily occurred in France, which is where their cause of action arose for purposes of Delaware borrowing statute. And there we go. I wonder what Tennessee's borrowing statute is, because it's almost like they're arguing two different things. One, it doesn't belong in Delaware, but if it belongs in Delaware, you can't hit us with the statute of limitation. I'm sorry, you can't hit us because of statute of limitation. But what is it in Tennessee? Because if the judge just says, fine, send it to Tennessee, and let's say Tennessee has a different approach to it, I'm just wondering how that would play out. But I don't see them punting it. But we'll see what happens. Next, Delaware courts compare the state's domestic statute of limitations for defamation with the foreign jurisdiction analogous limitation period and apply the shorter of the two. So we know that the shorter of the two is the 90-day clock and the 3-month clock. As Mr. Dreyer explains, the statute of limitation in France is 3 months and occurs from the day the allegedly defamatory remarks were first made. Really? Okay, there we go. I didn't see this part. So the first moment that she made the complaint, that was like in January. Yikes. Okay. The 3-month statute of limitation applies regardless whether the Macrons characterize their claims as defamation, false light, or defamation by implication. Okay. Now I got you. Okay. The majority of jurisdictions that recognize this false light tort have determined that the statute of limitation for defamation applies to false light claims, including because applying two different statutes of limitations to false light claims and defamation claims would risk the false light tort engulfing defamation, thereby producing a chilling effect on First Amendment rights. And neither law nor logic justifies a different statute of limitation for false light and defamation claims. Collecting cases, internal quotation marks omitted, restatement of this law right here, where false light is based on defamation statements, or rather defamatory statements. It is arguable that limitations of long standing that have been found desirable for the action of defamation should not be successfully evaded by proceeding upon a different theory of later origin. So they're saying when first thing, okay, that's where the 30-day clock. So the first day that the Becoming Brigitte series started is when the 90-day clock started. So, okay, that makes sense then. What do y'all think about that? So they're going to get it thrown out because of a technicality. And somebody said this right here. Yep, there it is right there. It does seem like they're going to get them on technicality. Or they're trying to, at least. Trying to. But see, the thing is when you first said it, not when it's the first time you said it. So if I were to defame you, Lila Rose, it would be today, September 16th, is the first day I said something bad about Lila Rose. And that would be the day that the 90-day clock started, assuming we lived in France. So that would be the day that the 90-day clock started. Not the last time I said it. Interesting. Okay. So what would be 90 days from here? Would be December 16th. Yeah. So December 16th would be the end of the 90 days. So on December 17th, I don't know if it starts up again, but if I sue you on December 17th and we lived in France, then I would be outside of the 90 day, the 3-month shot clock, and I wouldn't be able to do it. Here, because France's 3-month statute of limitation is shorter than Delaware's 2-year statute of limitation, the shorter of these 3-month period applies to the Macron's claim. Oh, here we go. This probably makes sense right here. Applying France statute of limitation to the Macron's case. Indeed, the latest statement based on the Macrons have sued allegedly occurred on February 20th, 2025. Okay, and that's on count 20 of their case. The Macrons filed their complaint on July 23rd, 2025, well after France's statute of limitation expired. Further, no tolling or similar doctrines under French law exist to resuscitate those claims. Okay, so they are saying that the last day of the becoming Brigitte. So that would have been February to March to April to May. So they're about 2 months behind since they filed it on July 23rd. Interesting. For these reasons, Delaware law requires that the court to apply France's 3-month statute of limitation to the Macron's claim. And under France's 3-month statute of limitation, all the Macron's claims must be dismissed as time barred. Interesting. Okay. I mean, it makes sense now. I'm reading it out loud. It makes sense, but we'll see. All right, let's go to part C. The doctrine of forum non-conveniencing also supports the dismissing of the state or staying this case. Under this doctrine, courts may decline jurisdiction over an action when litigating in the plaintiff's chosen form would be inconvenience, expensive, or otherwise inappropriate. See, to me, I don't think that's a good one because Candace said she didn't care. Like, bring it on. She said, bring it on. To me, you can't say it's an inconvenience. You can't say it's expensive or otherwise because you asked for it. You asked them to. The doctrine of forum non-conveniences allows courts to exercise their discretion to stay or dismiss a case in favor of more convenient form of resolving the dispute. That was interesting. I would love to hear an attorney explain what does this mean. So they could say, hey, a better way to deal with this is y'all go out in the backyard and fight, and whoever comes back is the winner. How do you figure this part out? To determine whether to dismiss a complaint under this doctrine of forum non-conveniences, the court looks at the cryo-made factors, which is, I wanted to say crypto so bad. I don't know why I want to say crypto so bad. Overruled in part on other grounds by the PepsiCo Inc., PepsiCo bottling company. All right, let's keep going. Under the cryo-made, the court must consider the relative ease and access of proof, the availability and compulsory process of witnesses, the possibility to view the premises if appropriate, whether the controversy is dependent upon Delaware law, which the courts in the state should decide whether rather than those of another jurisdiction, dependency or non-dependency of a similar action in another jurisdiction, and all other practical problems that would make this trial easy, expeditious, and inexpensive. To me, that last part, like you ask for this. You ask for this, Candace. That's the part I just don't get. I don't know if that's going to come back and be like, well, Your Honor, she asked for this. So we're just giving her what she asked for. Where defendant establishes through the factors of the litigating an action in the plaintiff's chosen form will result in overwhelming hardship and inconvenience, the court should dismiss the action. The form non-conveniences factors point to dismissal. Here, each of the cryo-made factors favor dismissal. All of the Macron's claims depended on, one, witnesses and documents located wholly in other states and countries. That's just hilarious. I can see them trying to ship boxes over from France, many of which are beyond the subpoena power of the court. Two, the analysis of foreign law that includes specific procedural protections for defamation cases. And three, public interest in the state of other states with results to non-Delaware plaintiffs and misconduct and injury that are alleged to have occurred outside of Delaware. Thus, Delaware is improper and unsuitable forum. Okay. This is such a wild ride. Okay, I'm gonna definitely highlight these ones. I just kind of breeze over these ones. And you are welcome to check them out. I think there's just these last 3 or 4, rather, please forgive me, high watermarks. I think they're pretty informative. So let's just go through them real quick. The first 2 cryo-made factors, the relative ease and access of proof and whether compulsory process for witnesses is available, weigh substantively in favor of dismissal. The first 2 cryo-made factors require the court to consider the relative ease and access of proof or whether compulsory process for witnesses is available. Can we get the witnesses here? Because we're going to be moving from Tennessee to Delaware, and will it be easy to process witnesses here? No, it's not. So you should just throw it out. It's basically what they're saying. Right. And same thing with, and they're going to talk about subpoenas in a second. Let me scroll down a little bit more. B, the fourth factor. Well, wait, did I miss? Where's 3? Did I miss one? The first 2, right. This is the 4th. Did I miss one? All right. The 4th factor, whether the controversy is dependent upon Delaware law, weighs heavily in favor of dismissal. The 4th cryo-made factor, whether the controversy is dependent on Delaware law, favors dismissal too. When applying the 4th factor, courts consider whether the controversy is dependent upon the application of Delaware law, which the courts of the state more properly should decide than those of another jurisdiction. So wait, if you're gonna make us come to Delaware, then y'all need to look at it and say, hey, there's really no reason to be here. So y'all should just kick it out of here. I'm wondering how difficult would it be to say they won't dismiss it, but they'll just send it over to Tennessee and let them duke it out in Tennessee. Because it just seems like they want both of them. They want to say, hey, it's not supposed to be in Delaware, but if it's in Delaware, you got to apply these Delawarean rules, which are an amalgamation of French rules. So you might as well just throw it away. That's what I'm getting. But conversely, Delaware courts must give reciprocal weight to a defendant's interest in having important issues of foreign law decided by the courts whose law governed the case. Yeah, I'm still kind of wondering about that 90-day shot clock, though. This action was brought to the citizens of France against citizens of Tennessee. This action was brought by citizens of France against citizens of Tennessee regarding statements made in Tennessee that purportedly injured the Macrons in France. Thus, the case relationship to Delaware is highly tenuous, and Delaware law will not apply to it. Okay. I can kind of dig that, though. Like I said, man, they're making a case. Whether I agree with it or not is definitely up to discussion, but I can understand the case that they're making. Let's keep it going. The fifth factor, pendency and non-pendency for an action elsewhere favors dismissal. Because the Macrons chose to file in Delaware, no action is pending elsewhere. Consequently, if the Macrons were to refile the case in Tennessee, there is no risk of overlapping proceedings that would result in imposing the burdens of duplication. To the contrary, because the case is in the early stages and the parties have not conducted discovery, there would be virtually no burden for the Macrons were they forced to file a new suit in Tennessee, where many of the issues rise therein, or rather herein, would be resolved. Like, look, if you just send it to Tennessee, we can settle it in Tennessee. But see, if they went to Tennessee, who would they sue? Would it just be Candace and not the LLCs, hers and her husband George Stom's LLC? Like, what would that be? Interesting. Let's finish this up. We are rounding the bases. I do want to get down to the conclusion. The conclusion is one sentence. I love it. All right. The sixth factor, all other practical problems that would make the trial easy, expeditious, please forgive me, and inexpensive weighs in favor of dismissal. In addition to evidentiary and legal problems that will arise in the case proceeds in the court, numerous practical considerations favor dismissal. First, the case should be dismissed because it would require the court and potentially a Delaware jury to expend time and resources on a dispute that has no meaningful connection to the state. Okay, I kind of got you there. I mean, there you go. Let's keep it going. The imposition of the jury duty for the people of Delaware for a trial which they have no interest is unfair. Okay, I can dig that. Litigating this case in Delaware would impose an unfair burden on the citizens of Delaware. Neither of the Macrons resides in Delaware, and in fact, they do not assert that they have ever visited or spent any meaningful time in Delaware. I mean, how many people have? How many people really been to Delaware? What's in Delaware? Umar Johnson. That's the only one I know who's there. Umar's there. That's hilarious. Presumption in favor of the plaintiff's choice of form not as strong as out-of-state plaintiff. Delaware's only connection to this case is the two corporate defendants were formed under Delaware law, but that is by itself is not a sufficient contact to choice. Delaware as a forum. But why not, though? That's what I don't get. Like, why can they not sue you because you have your businesses formed and housed in Delaware? You did that because of the tax benefit and the ease of starting your LLC. So isn't that part of the reason why you did this? Second, as demonstrated above, Mrs. Owens is not subject to personal jurisdiction in Delaware. Okay, we got that part. Following her dismissal and an action here against the other two defendants would create additional significant and overwhelming hardship for defendants, which would be forced to litigate the overlapping issues of two separate fora and subjected to potential inconsistent rulings. By contrast, if the action is dismissed, on forum non-conveniency grounds, the Macrons could refile in Tennessee and obtain personal jurisdiction over all defendants. This is a much more efficient path, especially considering that it would be easier to gather evidence and obtain witnesses at depositions and trial in Tennessee. At bottom, this is a defamation action and has no legitimate connections to the forum, and litigating in Delaware presents an overwhelming hardship to defendants. Therefore, defendants respectfully request that the court dismiss this action under the forum nonconvenience doctrine. And let's get to the conclusion. What's the conclusion? For the foregoing reasons, this case should be dismissed in its entirety. All right. All right. And this is all the important people that have signed it. It was signed on September 11th and it was filed on the 12th. So a lot of people were asking, didn't she have to file it by the 11th? And she did. She did technically file it, or rather it was issued on September 11th and it was filed with the court on the 12th. So I guess since it was issued, that counts. It didn't go beyond the date. All right. It makes sense. I want to give them credit. Yeah, y'all know I like to give credit. It makes sense. I don't know if, I'm not a judge, of course. I'm not even a lawyer. I'm a pre-K law student. That means I know nothing. It makes sense. I understand some of it. To me, having your business in Delaware means that you can be sued in Delaware. That's what I would think. So the fact that you live in Tennessee is outside the fact to me. The 90-day shot clock, the 3-month shot clock, I don't know if I agree with that one, because it doesn't seem like they established that in France it's truly the first moment that you say. That's kind of crazy, because they were already in the middle of a defamation case with the 2 journalists in France at the time. And that case had been resolved, and then they started the lawsuit here. So I don't know if that, I think personally, I think the judge is going to keep it. They're not going to throw it out. They're not going to say that it's French, so we don't worry about it. And they're not going to say it's going to be a hardship or inconvenience. I think they're going to probably keep it. I mean, that's just my observation. I can't see any other way. I mean, now maybe the judge says, hey, I got some other stuff to do. I got a golf trip coming up. I don't want to be dealing with this. The judge could throw the whole thing out. I mean, I don't know how long they have to respond or hear arguments about it. So we'll just keep our ears down to the ground, right? But that is it. What do y'all think about this crazy case? Yeah, I don't know, man, because it seems like she has said a lot that would be uber problematic in my mind, that would set that 90-day clock. Even with France, like, I don't understand, like, if they keep saying it, does that reset the clock? I didn't get that part. That's why I wasn't certain. Or is it just when the first time you said it, you got 90 days, and then on the 91st day, you can just be mad reckless? I don't know. But I do know this. Shout out to MT. Thank you so much. Dropped a comment earlier, but had to leave before response. Resending. Would love to hear your thoughts on Candace's Charlie plus Israel conspiracy. I'm going to look into that. Thank you, MT. I believe you're still here. Thank you so much for the very kind $5 super. I mentioned earlier today, I said I'll look into it, and I believe my editor actually grabbed it for me, so I will be looking into it. And I did say that I think it's kind of inappropriate to be like just theorizing and tinfoil hatting what happened to Charlie Kirk. To me, I don't think that's good form. And given the fact that she alleges that he was her friend and they had a tight-knit relationship, which a lot of people do affirm. So why would you do that? Like, to me, why not just go be quiet with his wife and kids and cry with them and hold them and cuddle them and just be quiet? Why literally, because I think she started that foolishness on like Thursday. Why on Thursday did you wake up and say, oh, I got an idea. These people deleted this guy. Not even a good 24 hours later, you rolling out with a conspiracy. That was wild work. So, but thank you so much for the $5 super for sure. Charlie's pastor addressed Candace directly. I might have to look at that. I saw your comment. Thank you for the $2 super here as well, MT. I'll look at that as well because I had not heard that until you just said it. So I will look into that and see what it's about. But thank you very much for the very kind super chats and the such of that nature. What else we got up in here? Thank y'all so much. Yeah, I just can't imagine. Like, I have some really good friends, and I would die inwardly if something happened to them that gross. Is like literally, we all watched it. And then for me to be like the next day, hop in the booth and be like, hey, I got a theory about what happened to, like, that's just craziness, man. Like, go sit with it. I mean, if it's a conspiracy, it'll still be a conspiracy. It'll be a conspiracy next month. It'll still, I mean, good gracious, at least let a whole week pass. Yeah, I just like, man, I don't see what the benefit of that was. And again, you made that heartfelt plea that he was your friend, he was your brother, y'all were thick as thieves. Then why was the first thing you thought about to run over there and start talking about how just so conveniently the people that you love to whip on, they're the ones that deleted him? Okay. I really don't think her and Charlie were as close as they were in recent years. Oh, realtor, I don't disagree with you. But, history is told by the people that tell it. So she's telling the story. I don't have any way to confirm otherwise. So I'm just going to take it at face value. But I agree with you, though. She said it the very next morning, and Candace's friends Ian did it the same day. Like, yeah, like that's crazy work. Like they can go on to have that. Y'all going to have that. I don't think there's any benefit or value in that type of stuff. And hear me, I like a good conspiracy every now and then. I got a little bit of tinfoil in my hats as well. I can respect the conspiracy, but that was just a lap too far, in my opinion. And like, hey, why? Yeah, you could do so much better. There's so much more good you could do instead of like, oh, let me roll out, because everybody was looking at it for a conspiracy. Actually, like, why do that? Yeah, a lot of people. Matter of fact, she even jokes about this. Where did she joke about this? Where she talks about her hormones are out of balance. To me, like, it's not a good look. There's so many other things she could be doing, but I'm not surprised. So I don't know why I'm not gonna act brand new. Like, oh, I'm surprised. So, I mean, people were expecting her to roll out with a conspiracy, and she didn't disappoint. So, I mean, she did disappoint, but you got my point. All right, I'm looking over here just to check and see if I missed anything. I appreciate y'all. Thank you guys so much for rocking with me. I did reach out to a couple of lawyers and they weren't able to jump on today. But if we are able to talk this week, maybe we'll do something, Thursday or Friday, or maybe even tomorrow, Wednesday, if somebody's available, so we can talk about it and answer your questions pertaining to it. But that is the motion to dismiss. YouTube seems to be a truth serum for many people. Okay, Willis, I appreciate that, brother. I can respect that. Oh, here we are here. Yeah. And to me, I think that's going to be a part that comes back and bites her, even though the dismissal was really about procedural and technicalities, like the law in France versus the law in the United States and so on and so forth. I do think that they just kind of overlooked what they were suing her for. It wasn't just some, hey, you did a documentary about the French president coming to power and we didn't like it. No, you said some pretty bombastic things. So I'm looking forward to seeing how it all pans out. And matter of fact, the docket as well, I'm going to put that in the description also. because this is what I keep looking at to see when they update more information pertaining to the case. So I just added that to the description as well. What is this? Oh, I can't do it because I'm literally in the stream right now. So I'll put it in the chat right here. So this is the docket. So that's the docket if you want to follow that. And you can see that they filed this on the 12th. Correct. But that is a correct point, Abert. I'm blending in with the dark. Okay. I was just messing with my lights. There I am. I'm back. Linda says this, I have no pictures of me being pregnant, but I birthed 3 children. Her oldest was 9 when her youngest was born. She's protecting their privacy as she should. One is now 49 and 47. No argument for me. We talked about this before. Like, a lot of us don't have pictures when we were kids. That was not something that was uber common back then. Now, of course, it's almost unheard of. Like, wait, you don't have pictures. You don't have 12 pictures of you yesterday. What are you talking about? Well, how's that great? Like, what's going on? Like, my girls every day when they get going in the morning, they send a picture to each other about what their fit looks like every day. And I'm in the group text. So I see this picture of all of them. Like, what? Why are y'all doing this? So, I totally get it though. But thank you so much for that. Yeah, this is going to be a wild case, and I really am looking forward to seeing how it pans out. I really appreciate y'all. Let's see. Make sure I didn't miss anything over here. Okay, so my poll was, do you think this case will be dismissed by the judge? 28 said yes. 28% said yes. 48 said no. And the rest, well, then 24 also said no. They said, but they did hit that like button. So shout out to y'all. Thank y'all, everybody who did tap in with us this evening, making sure that we hit that like button. Absolutely. We had 76 people hit the like, 97 watching. So go ahead and hit that like button if you didn't do it already. All you gotta do is just touch it. Just touch the button. Let me see if I missed any good commentary in the chat right here. Heather said that the lawyers are thriving in minutia. Let me see where these attorneys. Yeah, I mean they like it, and they getting paid for it too. Imagine how much they probably got paid to write that. This is an interesting point. Thank you, Linda. The Macrons issued a complaint early on and continue to notify Candace to cease and desist, even though she declares she didn't see them in her own email system. That is a good point. Does that start the 90-day clock? Does only filing a lawsuit justify the 90-day clock or the 3-month shot clock? Or when they sent you the message that said, don't put out the series, did that start it? And does that count as saying that you got it going? That's a very good point. Thank you so much for that, Linda. Shout out for sure. I think that's a good, I'm looking forward. I will write that down as a question when we get our, a lawyer on. Hopefully we'll get the heavy metal lawyer to come back on. We'll get a new friend to come on and talk about it. Let me just check real quick. Make sure I didn't miss it. I would love for them to come on tonight. Okay. No, that's a great point. Shout out to you. Thank you so much for that, Linda. But everybody, thank you so much for rocking with me. Thank you so much for, as always, supporting the channel. Thank you for jumping in to these live streams like this. Tomorrow is Wednesday. I don't think there's going to be any replies the rest of this month related to this. But if there is, I'm going to be back up in this piece. Thank you so much for it. If you want to read the docket, that's where I've been following the timeline as well. I just dropped the docket right here, and I'll make sure I put it in the description when we get done. as well as if you want to read the motion that I went over, it's in the description also. You can definitely check it out. Give me a 2 cent. If I missed something or better, if you better understand something, or if you're a lawyer and you want to help me out, help a brother out. I'm a pre-K law student. I don't know what I'm doing over here. But I do want to say thank y'all so much for rocking with us. Thank you for all of your support. It means a lot. I really do appreciate it. Let's do this again real soon. So until then, everybody, grace and peace. Take care. Thank you so much for tuning in to another episode of the Jay Witt Podcast. If you enjoyed today's show, please do me a favor and hit me up with that 3-piece special. Like the video, subscribe, and of course, share it with somebody who would also enjoy this type of content. And make sure you leave a comment because I do pin the best comments to the top. So thank you so much for tuning in today. And until next time, everybody, grace and peace.